intentionally or accidentally. The injured or the aggrieved party is compensated by the payment for damages. Damages may include compensation for loss of property, medical expenses, mental or physical incapability, pain and suffering, and punitive damages to punish the wrongdoer. Most of the claims that arise under civil suits, except contractual claims, are governed by the tort law. The intention of the tort law is to provide relief from wrongful acts of others through monetary compensation. And without further delay, I would like to give the introduction of our guest speaker, Ms. Artia Sana ma'am. Ma'am has done BA LLB honors from Dr. Ram Manohar Lohia, National Law University, Lucknow, and her LLM in IPR from Hidayatullah National Law University, Raipur. Went on to pursue dual LLM in International Law from University of Westminster, London. Ma'am is currently teaching as assistant lecturer at OP Jindal Global Law School and is a member of British Institute of International and Comparative Law (BIICL) and columnist at Clarion, India. Now, I would like to call Ms. Artia Sana ma'am to address the gathering. Please, ma'am. Okay, ma'am.
Hello, everyone. Very good afternoon to all of you. So, how are you? Like, this is my first physical class after COVID, and it's thrilling, to be honest. So, myself, Arshia Sana, long-winded description about me has already been given. And to be honest, I don't like long-winded introductions. I think your work speaks for yourself. And to add to that, this is not a lecture, okay? Because I don't like monologues, I like dialogues. It has to be an interactive session. You ask, I answer, I ask, you answer. Even if you don't know, even if it's, just wild guesses or anything like that, but you should interact because I don't like sleepy heads in my class at least, okay? So on that note, let's start by right. In the meanwhile, I got to know from Kathy and Shubhangi that some of you have already studied the law torts or tort law. So I guess that my audience is already having a heads up on the subject. However, I'll be starting with zero for we have some new starters here. So anyone would like to volunteer and give us a heads up on the subject? Third semester students. Third semester, right? Come on, guys. But I'm not that old. Okay. So you don't have to be shy in front of me. And I'm learning with you. It's just that you are on that side of the table, I'm on this side. I learn by teaching, you learn by listening and participating in class. Okay, that's the only difference because when it comes to law, no one can be the master of law, no one can be the teacher of law. Okay, you are always a learner because law keeps growing, and with that, we have to keep growing. We cannot say, okay, yeah, I have reached this. This is the top notch of the subject. This is the top notch of law, and I have reached it and I know it all. You can never do that. I mean, you can keep progressing. You can keep working on yourself. You can keep enhancing your knowledge and skills, but you can never be the master of law. So I think it's always good to say that you are a learner of law, you're a student of law, and I am a student of law. I learn law by teaching it. Okay, your questions or your suggestions, feedback, comments, queries, they add to my knowledge. Okay, and that is how I keep growing. Why is it connected? right? I don't want to bore the students. Right before. I guess this is the new student side. Am I right? Okay. First and very pathetic question, which is going to piss you off for the next 5 years. Why law as a career? Come on. I want interesting answers. Okay. Yeah. Huh. Yeah. Okay. So you are for judiciary. Wow. And that reminds me of the days when I started my law school and I was so head over heels for judiciary. And how that idea declined, and now I'm an academician. I mean, I'm proud of it. That's by choice, not by chance. I didn't even try for judiciary even once. But things take their own toll. Okay, you think something else, and then you discover new things. In these 5 years, these are going to be your life-changing 5 years. And guys, don't worry about the grades. Okay, take it from me. College is not about studying. You have done enough of studying in your schools. Okay, Indian education system is like that they make you donkeys. I should not be saying this on record, but it is what it is. So don't worry about studies, or don't worry about the grade. Of course, you have to study. Instead, college is more about your personality development and your approach development. It develops your approach for every coming aspect of your life. Okay, how you're going to approach the rest of your life, you are going to develop it in these 5 years. So these 5 years are going to be the most crucial years. And I won't say that don't make mistakes in these 5 years, because these are the most crucial 5 years. No, please don't do that. Not making mistakes in itself is a mistake. Make mistakes. Just be sure that you don't repeat a mistake. Okay? With every mistake, we learn something. Agree? Okay? One mistake, you learn something. All right? Not repeating it, being creative, being innovative with your mistakes, making new mistakes, learning new things. Okay? So that's another domain of learning. So make mistakes in these 5 years and learn. Don't be a repeat offender. Okay? Just keep this in your mind. Because no one, especially in the field of law, and if you want to practice law, or if you work for a law firm, or you want to be a law academician, take it from me, no one wants a boring candidate. Okay? You know all of laws, which I don't know, to be honest. You know all the laws, you know how to apply it, but you just don't have that right kind of approach of like talking with people, or handling the situations. Okay, because these things you learn from your experience. No textbook, no law book, nothing can teach you. Only your life and your experiences can teach you this. I think enough of preaching. We'll sleep. Today we are going to, do we need mic? Because I think I already have very loud voice. Am I audible? So today we are going to discuss international not aspects, I think in the integration and aspects of the master. I mean, we can go ahead and discuss the international aspects for sure, but that very
lecture this short. So we are not going to discuss the international aspects. Rather, we will say that it is the international application of tort law. Okay, leaving behind the Indian context, which does not accommodate the tort law in such in a very welcoming manner. So, starting by the basics of the tort, the meaning and definition. Tort is derived from the French word automatic, you can see on the screen. This word means twist. Yeah, not read. So, French word tortle translates in English to twist. Okay, and the legal interpretation of the word tort is wrong, majorly civil wrong. So, how does twist and wrong go with each other? Any guesses? Yes.
Mom, basically, the law teaches us just be straightforward.
Okay.
Mom, the law teaches us just be straightforward towards the law and straightly follow it. And here, twist effort that you can distract it towards the law.
Yeah, that's a very good word. Thank you. So, law.
All right. So, yeah, you are right, partially. Law demands us to walk on the straight path. Okay. Now, if someone deviates from the path, okay. Wow, such technological advancements. I mean, we used to have such in our class. Okay. So, yeah. Like law demands us to walk on the straight path, and if you take twists and turns, and your twists and turns cause interference with the freedom of other people, with the enjoyment of their rights, that means you are twisted. Okay, and your twist is a civil wrong. So this is how the French word tort or twist and civil wrong goes hand in hand with each other. Tort is, as we all know, is civil wrong. It is civil in nature. The damages of the compensation, say in the law of tort, is unlike criminal law. It's not punitive. Okay, it's compensatory. It's like reinstating the status quo. Okay, you did something and now you have to reinstate it to the status quo. Like you have to reverse the situation, compensate the person, and make it level. Okay, so this is more like tort. In tort, the rationale is not rationale behind punishing or compensation is not to punish the wrongdoer, rather compensate the plaintiff, which is unlike this is playing with you. Okay, so which is very unlike the criminal law, and that's the major difference between tort and criminal law. Another major point is all So all torts are civil wrong, but all civil wrong are not necessarily tort. For example, the breach of contract, breach of trust, they all are civil wrong, but they are not tort. Okay, so that is the major nature, the predominant nature of the law of tort. Okay, now that takes us to the tort versus crime. We know tort is against the individual. Okay, it is a private wrong, unlike crime. Crime is the offense against the state. Tort is a wrong against one person. Okay, so that is the major difference between tort and crime. That tort, tort is how to put it. I mean, if I do if I violate the uh, individual rights of, let's say, Kathy. Okay, so I'm not going against the state. It's between me and Kathy. Okay, like it has been in college. Okay, so so it's between me and Kathy. State has nothing to do with this problem. Okay, now if I go ahead and assault Kathy, or say sorry, Kathy, I'm so sorry. I'm never gonna do it. Or I kill Kathy. Okay, so that is the crime. That is on against the state, because this time I'm bettering the society at large. I'm bettering the public at large. Okay, today I kill someone. Tomorrow I can go ahead and kill another person. Okay, so in this case I'm liable for punishment, a detrimental effect that can be felt by others in the society, that yes, if you do something wrong against the state, this is going to be your condition. All right. However, criminal law is not in a very good state in our country. Damages in tort are unliquidated. Unliquidated means they are not fixed beforehand, unlike your criminal laws. In IPC, Indian Penal Code, certain offenses have certain punishment, fine, imprisonment, life sentence, and in tort, it's the situation. In every law, every case, judges decide the damages, and whether based on precedents are already decided case laws. So based on the precedents, or the facts of the case, judges decide the compensation or the damages that have to be awarded to the plaintiff. Like case to case basis. Tort litigation is compoundable. What does that mean? Any guesses?
It can be solved out of
Yes. Who was that? Good. So you can retract litigation, okay, which you can't do in the criminal law. I mean, you have certain procedures for that. It's not A versus B. A does. I like it the conventional way. So wherever tort litigation is compoundable, which means that it can be retracted. A versus B, B harms A. A wants to do the out of court settlement, or A, let's say, forgive B, or B has to give certain amount of money to A. Now A wants to retract his complaint, and he's free to do that. It is compoundable. This is how, I mean, that is what compoundable means. You can retract your complaint. Let's discuss some of the history of the case law. Guys, don't judge on my presentation, because that is the 11th presentation I've made, because Shubhan, so it was like, our students don't want that you keep blabbering and they keep listening. They to see on screen. So I made it in like one hour or so. So his tort is one of the oldest laws, and why it is different civilization before the law and order, like the present legal systems came into existence. It was the era of kings and emperors. So the Code of Hammurabi, which is 4,000 years old, like 4,000 years approximately from today, the Code of Hammurabi by the king of Hammurabi being the king of Babylonians, they codified their laws, and most of these laws uh, amounted to be tort law. I mean, most of these laws, which were codified by then, around 4,000 years ago, if you see them now, most of them qualified for the requirement of tort law. Okay, for example, Code 245 of the Hammurabi Code. What does it say? It said that if someone hires another person's oxen and kills it, treatment or bad treatment or lending it to someone else or by anything, it kills their oxen. Now they have to compensate. Compensate how? Give more like equal number of oxen to them. Okay. Now we today tort law is more like that. Like it's compensatory in nature. You did something wrong, you have to compensate for it. Now, in modern tort law, if you do something wrong to someone, you got to compensate like the Code of Hammurabi. Similarly, Romans, which provide the basis of English legal system, they also had certain laws which now qualify as the tort law. So they had a series of laws which was about compensating people for the damage unlawfully inflicted by the defendant or the tortfeasor. So in tort we have plaintiff and the defendant. Defendant is the tortfeasor. Now, in English system, this Roman-inspired tort laws, this was formulated in the writ of trespass in some 1200s. I mean, it was the same century when the Magna Carta was signed. So, quite old. The writ of trespass or the origin of tort law in the English legal system is quite old. Now, the writ of trespass was later later added on by the writ of negligence when people, but their claim does not qualify for the tort of negligence. For the writ of what was the first writ? No. I'm discussing right now. You guys are sleeping. Writ of trespass. Okay. Yeah. So years later, like the writ of trespass was the first tort law to be passed under each system. Then it was succeeded by writ of negligence, and it was passed for cases claimant could not get the remedy or that the rate of trespass. So that means the defendant did something which was, but it just did not qualify for the trespass. So there came the rate of negligence. Yeah, tort law and different legislation. For a legal system like defined tort, okay, some of the legislation talk about tort law, but they have only given a definition of the law. Okay, so it's not very cogent, it's not very comprehensive, it's just residue. So tort law is being different by states, okay, not the states like we have in different legal systems in different. Should I go away with this? I have difficult task. So, tort law is codified under different legislation. For example, under Motor Vehicles Act. If you see the Motor Vehicles Act of countries like UK or Australia or USA for that matter, we see that it covers various and huge range of insurances that people can claim under the can cost to them by in this case, it is covered majorly by the Motor Vehicles Act, and when these legislation covered, I'm not speaking about because in India we don't have a codified tort law. So when these specific legislation cover specific tort, then people are more likely to incline towards those specific legislation, and they are more of the inclination that they file their suit under that legislation and not the traditional tort law. Now that leads me to Workers' Compensation Act. If a person is injured in their workplace, the cost of treatment, rehabilitation is provided by the employer. Self-explanatory. Next is consumer protection laws, which we also have in India. They deal with a lot of consumer complaints, a lot of wrongs by the producer, which are wrong for example, misrepresentation. Okay, misrepresentation is a type of tort, and consumer protection laws allows the consumers to claim compensation and other remedies if the goods and services don't work or harm the consumer, and it covers a lot of torts including misrepresentation and negligence. It reminds a current case of Dono versus Stevenson. You must have read about it. If you have read tort law, I mean, tort of negligence start from there. All right. So Dono versus Stevenson is the breeding ground of the wrong sort of negligence. Okay. We'll be discussing it in the later slides. Now that's the consumer protection laws. Now tort law and environmental laws. These days, with the spreading awareness about the environmental degradation and the climate change, there are a lot of lawsuits which claim public nuisance by the corporate giants. Okay, especially the companies which are mining or extracting energy, or if they are into coal plants. Okay, so these business giants, and it got huge climate change. Okay, and the effects of it is seen by all of us. I mean, some is the who is at the okay, we see accidented floods, droughts, thunderstorms like Delhi and the northern parts of India, especially Delhi, Lucknow, from where I come. We have seen unprecedented rains in the recent time. In September itself, the rains which happened in this month, rains like that never happened before in. So that is qualifies under the law of tort, and it is majorly public nuisance and strict liability, which causes a lot of environmental degradation and environmental hazards by the activities of corporate giants like in the case of Madison versus Ducktown Sulphur Companies of 1904 and Georgia versus Tennessee Copper 1907. If you are, I would suggest you, I mean, strongly suggest you to read about these cases because these are one of the breeding grounds of environmental awareness, environmental litigation. Okay. Right. Tort versus torts. What's the difference? Don't tell me one is singular, one is plural. Other than that, absolutely nothing. Okay, it's just the different interpretation by different jurists. Okay, they had a lot of time, they played with it, and you have to study it. So Professor Winfield called it law of tort, and he said that all wrongful acts, whether named or unnamed, whether predetermined or not, whether known formally or not, they all are torts. Okay, even if they are newly made. Okay, like something like that never happened before. Like I just gave an example of English legal system. Writ of trespass was already there, but this writ wasn't just enough to accommodate all sort of civil wrongs. So then there was this need for another writ, that is the writ of negligence. Similarly, what Winfield says that all wrongful acts amount to tort, whether they have been predetermined or not, whether they have been prejudged or not, whether they have been pre-thought or not. Okay, Salmon plays with it. Okay, he said no, I'll do something new and I'll give this whole theory. Do I have whiteboard marker? So what was in his physics theory? He said this is the whole domain of law, and then you have pigeonholes, and we can put different torts in that. Let's say defamation here, negligence here, nuisance here, trespass, misrepresentation, and all other sort of torts. He says that this is it. Okay, any wrongful act which falls under this domain is a civil wrong, and it is how do you, it qualifies for the law of torts. His idea for law of torts was that these are all the torts. Okay, now any other wrongful act outside this domain does not fall under the law of torts, and it can be something. It can be a wrongful act. It can be a civil wrong, but it just it is not tort. Simple. That is what is written here. That Salmon's pigeonhole theory says that law of torts, there are some predetermined torts, and if the wrongful act in question fits within the ambit of a predetermined tort, fits in any of the pigeonholes there, then only it amounts to tort or not, or like not otherwise. So this is basically the difference between tort and torts. Very cool. Type. First is interference with person. Okay, before I go to that, what is essential for us? No. But how was your COVID? You know, Who's doing it? Body, yes. Health and body is the same thing. Come on, we all are materialistic. Our materialistic things, our phone, our books, our clothes, and everything and anything which is important to me is me. I don't want unnecessary and unwanted interference in my things. So, goods or material. And interference with the property. Property is the, and there are cases on property. How dearest is property for all of us. These are the three major essential things, like things of value, and or interference with these three things. So we'll start with the interference with the person. Yeah. So any voluntary act with immediate injurious effect on another person, where the tortfeasor or the wrongdoer or the defendant either intended the injury or was reckless as to the injury. So there are certain requirements to this definition. Like the main one is there should be a voluntary act. There should be a voluntary. What does that? What does a voluntary act mean? Soundness of this. He accepted that, knowing that it is wrong. Okay. Voluntary act is you someone and not the person. You guys are sitting with the other person. That is a voluntary act. Now, God forbid, if someone has a medical feat, okay, we are voluntary, okay, and if that feat touches someone, that is not a voluntary act, okay, that was beyond your control. That is first requirement of these type of torts. Voluntary act. Second is immediate injurious effect. Okay? And you are immediate. Okay? So whatever injury you incurred should be did. The third requirement is the intended injury or reckless action by the other person, meaning that intended to cause you harm. Okay, I mean it's not a mistake bona fide. Okay, you accident, you bruise one. Okay. Kick some. Thing. It is the requirement of the game. Okay, so it is covered by different laws altogether. Okay, and if something happens to playing these sports like football or cricket, then it is covered by the defense of voluntary non-fit injuria, which means you when you go on field, when you go in the ground, you give your consent for all the probable harms that can be caused. Okay, it's a different thing, and that if under the exception of voluntary non-fit injury. So here, if you one or you bruised by someone and they are annoyed, but your mistake was to talk. So these were the requirements. What? Voluntary act, immediate injurious effect of that voluntary act. Then the injury was intended and okay. So there are three types of torts which are categorized under the interference with the person. First one being assault. What is assault? We read it in newspaper every day. Assault, sexual assault. You're near there. Both action and words. Right. So yes, you guys are near there. Assault is attack, basically. Okay. It's an imminent threat. You don't touch innocent. There's no touch involved. If the touch is involved, it becomes battery. Okay. So for assault, what are the minimum requirements? We covered all. These are some of the cases which you guys can note down, or I can forward the PPT later. That takes us to assault. Number one requirement for the tort of assault is the threat, and that it can be verbal, it can be gestural. Okay, verbal like I'll punch you. Okay, I'll break nose. What? Gestural is you're not saying anything. Okay, gestures are saying everything. Okay, you are showing your fist to someone. Okay, you're not saying something, but you're just that you are a threat to them. Okay, so that is first thing that is offer of imminent threat, which involves no touching, just intimidating or threatening words or things like pointing gun, knife, showing fist, etc. Then there's this very interesting case, Reed versus Cooker. It's a very old case where the plaintiff was surrounded by the defendant's workman, and who said that they will break what? His neck. And this court held that this is a verbal. Okay. In another case of Tuberville versus Savage, it's an older case where the defendant said that I would have killed you. I would really like to pull my sword out and cut you in half, but because the judges are in town, I am not going to. That's a does it amount to assault? Sorry? Verbal assault. I mean, in previous case also it was verbal assault. I'll break your neck. It's verbal assault. Okay. In this case, what do you think? What the judges must have ruled? Was it an assault that if the judges were not here, I would have cut you in half? And you say, okay, yes, it was an mental assault. Okay. judges that it was not an assault because he did not find that imminent requirement thing in the threat. Yes, it was a threat, but it was not an imminent threat. It was just the eloquence of the defendant, which is portrayed in this sentence. Okay, so judges ruled no, it was not an assault. Sorry. Now the second requirement is threat of force or violence is necessary. For instance, threat of taking a photograph, which is the facts of the case, K versus Robertson. In this case, the threat was there that someone might take your picture and you, but still it is not assault. Okay, there's a threat to you that yes, your picture might get clicked and you don't want it, but this is not a threat of fear or violence. The violence quotient is not involved in this type of threat, so it does not amount to assault. Now, the third requirement for assault is a reasonable person believes the threat can be carried out and the classic case, sorry for the typo, and the classic case of unloaded pistol. Yeah. These were the facts of McLean versus Simons. Case that done by the defendant. But the defendant took the defense that the gun was not and I'm not that person. Yeah, that is what the requirement is not qualified for in this case, and hence was not an assault because a reasonable person would know that the gun was loaded. Pointing a gun at someone it induces imminent. So a reasonable person requirement is the third requirement for the tort of assault. Now the fourth requirement is that a reasonable person believes that the threat can be carried out imminently. And with imminently, it does not necessarily mean immediately. For example, case of Xantho versus Wazopus, what happened in this case? The defendant trapped the plane. He was asked from her, okay, and when she denied, he threatened her that he will take her, okay, and he'll take her to his. This sentence, this threat by him, imminent. Not imminent in this case. I mean, he reached at his mate's house in or half an hour, 1 hour or so. Okay. So the receiver, the plaintiff, does not know whether the threat is imminent, whether the threat is immediate or not. But the threat was imminent because she was under the control of the defendant. Okay, so it was very much imminent, and imminent does not have to do with time. I mean, it's not that like in the cases of extortion, where the defendant say that we owe such amount of money, or else we will kill the person, whoever, child, or wife, so in that case also, the threat is imminent. However, it is not immediate. You won't know when the defendant, when the wrong is going to happen. But you have this fear inducing. So those are the major requirements for the tort of assault. That takes us to battery. Battery is assault. So once this threat to violence become real, it's okay. What someone assault, actually shooting, like pressing the trigger battery. Clear? Now this battery has a very interesting requirement, which is offensive physical interference with the plaintiff's person. Now, what does offensive physical interference mean? To interfere physically, wow, that was very verbal. All right. Offensive physical interference is any harm, pain, bruise, which is first intentional. Okay. And you are about to fall. And the person behind you catches you from your clothes or collar behind or something like that. And he saves your life. This is the unwanted, unasked for physical touch. But does this amount offensive physical touch? No, why? Say the now you have to say the life. You're going on the escalators and someone bruised by relation. Alright? Or someone catches you from behind without any fear of danger, without they catch you behind or they push by you, or they push you, they pull you, they pick with your clothes. I mean, offensive physical does not only require the body. Anything connected to your body, but in a movie frame, the mobile phone is captured by the side, and some touches that also amounts to offensive. Okay. So that is one of the major difference between the offensive physical touch and the social touch. Okay. Now, the offensive physical interference, it does not require harm, pain, bruising. I mean, it's not necessarily cause you hurt. It's just interference with your person, with your body, touche. End of discussion. Okay. In fact, what was held in the case of Cole versus Turner, the least court held that the least physical touch may constitute battery. Slightest brush of the defendant's fingertip can constitute offense with a person of the plaintiff. Okay. Now, we get to decide who and in what sense touches us. The rationale behind that sort of it is our body, it is my belonging, and I get to decide. Okay. Okay. Except in the cases of necessity, like I gave you the example of escalators, you're falling and someone holds you from the back. So in that case, like in this decision, what was that on your and no one can do unwanted and unconsented touch upon you. Now, offensive physical interference, what normal social touching, okay, is like you are traveling, you are in an and you are accidentally, okay, or accounted for. Court held in this case of Collins versus Wilcox that normal social touching does not amount to battery, as it is not offensive, but it becomes offensive if the defendant continues to do so even after the plaintiff made it clear. Your for that matter. Immediately convert into made it apparent that you are. However, yeah. Now the offensive touch varies from society to society, from culture to culture. On what society we belong. We whether we are from the developed country where shaking hands, hugging, kissing each other is very normal. All right. However, in India, it's not that normal. Okay. So it depends. Offensive physical may mean differently. Just for this monk, it is very offensive. Okay, because he's a monk and she is not entitled to touch him. And at the first instance, it is offensive. That leads us to discuss the King versus Robertson case, in which court held that what sort of offensive touches, like what sort of action offensive touch, and it says that throwing anything, if I throw flowers at you, that is offensive physical touch. Okay, firing, shining a bright light, or pointing a laser at you. If it's for the laser, and I would point constantly towards your eyes, that is a physical touch. The last tort of this category, interference with the person, is the false imprisonment, which means the plaintiff, is confined by the tortfeasor by wrongdoer. It does not necessarily include whether the person was imprisoned or confined for an hour, for a day. I mean, time is not a consideration here. Even if you are confined for 1 minute, all right, like your class gets over and everyone empties the class, your teacher, you are the only person left in the class, your teacher locks the room. Okay, and then you start crying, or you started threatening or whatever, and they open the door and you leave. You were confined for a couple of minutes, but that was false imprisonment, and that is wrongful and unlawful in the court of law. For this, yeah, the time limit. Right, the time limit requirement for the false imprisonment was described in the Australian case of White and others versus Fox. Now that leads us to the three, which is interference with. Go ahead. Yeah. Yeah. You get the difference, which is very unlikely, because this is now a criminal offense that you are shooting someone. Okay, you may take the defense of however you can. You may take the defense of saying that I didn't know whether one was voting. There are certain peculiarities in this case, like for example, say you are minor. Okay, you may be acquitted. And if you're a major teen, criminal laws come into picture then. You getting my point, right? Offensive physical touch. Mhm. We start.
Intention is important,
Okay.
but not in every case. Okay. The lady touched the mom accidentally. She did not. She was oblivious of the fact that touching a
Monk is
permissible.
at him, and he showed a face that he's not comfortable. Like, woman, what you are doing? Okay. And she continues to touch him. Back. Okay. Prior to that, excuse. Okay, fine, you didn't know. But the monk made it clear through his facial gestures that he is not comfortable being touched. Okay, and now this is since this is apparent that the person is not comfortable, then you should refrain. Okay. Always. Yeah, interference with the goods. Any voluntary act, again, the voluntary act by the tortfeasor, which directly interferes with the plaintiff's possession of goods. We'll be discussing three torts here. Now, this category of torts, everyone knows the difference. I assume that you know the difference between ownership and possession. Anyone? Yeah. Like, very contemporary example, you book cab, Ola, Uber, okay? Till the time you are in it, it is in your possession. Okay, you don't own it. All right. So that is the major difference between ownership and possession. Trespass against your goods and trespass against your property. Yeah. So the first category of that is, which means unlawful entry upon land, which we'll be discussing in the next subhead, and we'll be discussing about the. Here we are concerned more about the second kind of trespass, that is trespass. This is the wrongful taking of goods. What happens in trespass is any intentional act which directly interferes with the plaintiff's possession of goods. For example, if the defendant, like in the case of Consolidated Company versus Curtis and Sons, in this case, the court held that if the defendant takes someone's goods and dispose them it and it, trespass, what happens is there's something, okay, and the defendant unwantedly simple anything, it comes and scribbles because of your simple. Now coming to conversion, I'm sorry, I mixed the two things earlier. Sorry for that. Now coming to conversion. Conversion is the intentional act that interferes with the plaintiff's possession of goods in such a fundamental way that it essentially excludes the plaintiff for the definition. Converting it, I give you something. I give, and you need it, and ask you, okay, you can keep it. So what you and this selling alone is not enough for conversion. You sold it to that person, delivered them. I mean, that car is now out of your possession. Okay, so that amounts to the thought of conversion. Converted by right of possession to your right of ownership. Okay, I didn't ask you, I gave you my card for your use. I didn't ask you, I didn't give you the authority to sell it or lend it to someone further. Okay, so similar were the facts of the case, Consolidated Company and Curtis versus Curtis and Sons. In the case of Curtis versus Willoughby, if the defendant takes goods in my possession and they take possession of that goods, conversion. What does that mean? For example, someone take my pen. It was at that time in my possession, and now that pen is with them. Okay, it may amount to stealing, it may not amount. Intention is that he it's different from stealing. Like this person took your pen, took your belongings, and your things are there in his possession or her possession. So amounts to conversion. For instance, like the example I just gave, I bail my car on the condition that I bail my car. You don't have to drive out of the city in the limits of the city. Okay, he took my rights away. Okay, and similar were the case facts in the Moorgate Mercantile versus Finch and Reed. Like I said, that it denies my rights to set limits on my goods. Similarly, if I loan my car and the porter loans it to someone else, yeah, and if that person ignore this typo, if I loan my car, that loans it to someone else, this amount again amounts conversion, like it happened in Hyrot versus Port case. That takes us to the tenure. Tenure is nothing but refusal to return goods after the demand for the return has been made. Now, the two things here are that the plaintiff, the complainant, must be entitled an explicit demand to return. Is you gave a project, your laptop died off or whatever. You gave a certain amount of time, okay, and now he is refusing to return. You have asked him return my laptop, I need. Okay. Now the demand. Let's review.
Starting with the immovable property, because what immovable property we have already discussed. The immovable property, the trespass against the immovable property is known as trespass for clause present. That is unlawful entry for marriage. Now, since we have studied the part of trespass, classified, and these are some of the listed in the cards which interfere with your enjoyment of right, with the enjoyment of right of your property. Okay. As a record which interferes with the enjoyment of the property is the injury to reversible rights. Now, a reversible is a person who has a lawful interest in land but not its present possession. Okay. For example, landlord and a reversible interest is any interest vested or contingent, the enjoyment of which is postponed. Okay, I'm the landlord of certain property, but I'm not decided tenants are there. But that property is going to revert to me. Okay, and I have the personal rights. I have the vested interest or the contingent interest in that property. So any injury that reversible right is injury to my reversible rights. Okay. Now, second, another thought is thought of waste, which is basically spoil or destruction of house, like or the residential or the person who is currently in possession of your property, they cause damage or destruction to your property. So this is another sort of and a form of sort is and damage must be of permanent nature and cause prejudice to the owner of the property. Third is dispossession, where an owner is said to be dispossessed of his income property when the defendant doesn't have overall dominion of the plaintiff over the property, or when the defendant acquires second possession of the land with the intention of acquiring exclusive control of the immovable property of the owner, which also amounts to criminal misappropriation or breach of trust, okay, or in the contractual terms, it amounts to breach of contract. Correct? So these concepts are set in basic English and nothing much to explain there. Now there are some other wrongs for the issues of property, that is wrongs in natural right and easement right. These are not possessive rights used by others any investment business. So public nuisance is an act of omission which causes any public injury, danger, or annoyance to the public or to the people in general, well, or occupy the property to make nuisance actually report. One must satisfy two important things, that is the act done by the independent inspector, and second, that the damage caused or the injury incurred is the direct consequence of that act. For example, the case is state of Georgia versus state of Tennessee, or Madison County versus Suffolk County. What happened in those cases? Discussing about the Madison County. In the year 1904, in the state of in the neighboring areas, the outskirts of the state of Georgia, the sulfur companies started doing copper mines, started extracting copper. Okay. Now, at that time, since there weren't much of technological advancements and machinery, how they used to do is causing devastating effects on the environment and the livelihood of the people of the local inhabitants. Why I'm discussing this case? Because it is one of the landmark cases when it comes to public nuisance. Okay, it's a case from USA. In this case, the court had the judgment was very interesting because the inhabitants, the local inhabitants of the area, they complain of the loss of livelihood. They complain of their degradation of their quality of life because with that mining and then bringing out the copper ore and then smelting it into different plants, this was causing a lot of air pollution, and the smoke was getting accumulated on the tops of the local inhabitants. Now the problem was, the chain was that these sulfur companies are causing a large scale public nuisance. Okay. Now, what do you say? Is it causing public nuisance or not? Why? Just affecting the crops of farmer is sufficient to claim the public nuisance. Yeah, okay. And on that, so you say that it's affecting the crops of farmers, which is true. You say that they don't have the knowledge, but it comes from they did not have technological advancements to mine in a proper way. Okay. The court considered both these claims. And what it said was very interesting. Why? Because it, in a very sugar-coating way, favored the business giants and ignored the local people and their rights. It said that the loss incurred by the local people is still able to be compensated. It can be a compensation, but if we put an injunction on the corporate companies, on copper companies, they have invested millions of dollars in their mining, and all of that is going to get wasted. Ignoring the fact that this mining has left hectares of land barren. Okay, and court very conveniently favored the copper companies and declined the injunction asked for by the plaintiffs. On the similar terms, in the year 1907, state of Tennessee versus state of Georgia is formed. And in that case, the defendants tried to convince the court that injunction. In why not in this case? The facts were similar. The corporate companies in the state of Georgia were affecting the quality of life in the state of Texas. But in this case, the court held, the Supreme Court of Texas, it held that it is a public nuisance caused by the corporate companies, mining companies in the state of Georgia. Why is it difference? Any guesses? Why such huge difference of approach in similar facts? It's just 3 years later, 1997. I mean, the facts are very simple. The companies in Georgia are using the same technology, whatever was present at that time, like it was in the Madison account. Everything is similar. The only difference is here the complainant was a state. Here the complaint was the state of Tennessee. It was state versus state. Okay, a sovereign versus another sovereign. And in the earlier case, it was private individuals versus corporate giants. Okay, and what again, interest is stake in the Madison account. You know what? The rights of locals and the rights of the people, then okay, they should be respected and they should be upheld. But whatever the companies are doing, this is not a betterment of the state, which is betterment for the state actually is. But it could have directed the company to adopt certain measures or to stop certain processes which could affect the environment less and could affect the local inhabitants in a lesser detriment. Private uses. Private uses is unauthorized use of one's own property causing damage to the property of another. Some unauthorized interference with the property of property rights of another. Private uses public uses. Very self-explained. Okay. Nuisance against public at large, public uses. Nuisance against a person. Private uses. I wanted to discuss it but before I discuss this case, I should have much more about it. Whenever you go to Starbucks or Dunkin' Donuts, in any big company selling coffee, especially on the mug, it is already written that be careful because the country is very hot. Written. Especially the red box of Starbucks. This is warning written. How did it come into picture? And why did it come into picture? What was it? There was this narrow value somewhere in USA. Narrow value. This we don't know swimming club. This is services corporation limited, and they had an amusement place in that well, okay, on the floor of that. Now, in the year 1905, these dependents installed a dance in that amusement. Okay, until 1935, this was okay. Now, in 35, they installed a dance floor, and this was enough. They had jazz nights, jazz music, almost every day in the months of summer. Okay, and this continued. I mean, this wasn't just a weekend concept. This was 6 days per week. I mean, every day he used to have this jazz concert and dance, floor, the loud music. And if this wasn't enough, they would have a shell, okay, on the dance floor in order to amplify the sound of the jazz music. Okay, I mean, to exacerbate the situation. Now the locals, the residents, which used to live on the hills of their country, they used to get really annoyed because the entire summer months they used to have significant disturbance with their peace and their quality of life. Like they were, and the music sound was so loud, so loud, so loud that they could barely sleep, study, or even hear themselves. They finally played against the Milo Swimming Club, asking that it is causing sincere public nuisance and this should be enjoyed. Our point was it is to be making it up. It is asking the army to put any habitual noise which is so loud, continuous, insistent, not inherent to the character of the neighborhood, and unusual therein that normal men, women, and children will occupy their homes, however distant, are so seriously incommoded that they cannot sleep, study, read, converse, or concentrate until trust is not an unreasonable, unlawful invasion of the rights, and the injunction was right. Okay. Any questions? Any doubts in your mind? Does it sound fishy somewhere? The residents getting disturbed by the loud sound of music, which started right in the evening at 9 p.m. and went on to until midnight. The residents asked for an injunction, and the injunction was granted. Clear? Okay. The second, even. Let's go ahead. In this case, Mrs. Blair sued Stewards, Mr. and Mrs. Stewards. She said that Stewards scared and Stewards were neighbors. And what Stewards did was they installed a swimming pool in the back. Okay. And Mrs. Blair, she was super enthusiastic for her plans and taking care of it all the time, and she was very peaceful lady. Okay. She only liked peace. She wanted no interference with her enjoyment of time, or no interference with her peace of mind or body to that kind of. She sued Curious on the ground that this flash of diving, jumping, it disturbs her, and the chlorinated water from the swimming pool is destroying her plants. Okay. What do you think should go aside? Is it useless? Okay. does the judge ask for both? Both are correct. Just that there's this extra element of sensitivity or oversensitivity of the plaintiff herself. So the court stated after much examination and considering all the evidence and everything, the court stated that first of all, viewers are enjoying their own time. Okay, they have installed a swimming pool in their own backyard. Okay, and it's their right to do whatever they want in the property, provided it does not affect the right and enjoyment of others. Okay, because no freedom ends where my own starts. Now, in this case, court stated that viewers have the right to enjoy. Second, Mrs. Sales is extra sensitive, and it is her oversensitivity that is what causing her problems rather than the gesture or the conduct of the viewers. Okay. However, let's try to take advantage of the love and try to convince the court in her favor. However, the court had a very interesting condition for nuisance, and it says, yeah, there was not sufficient evidence to establish a nuisance arising from noise in the use of the swimming pool. The same observations may be made in regard to the floodlights. Okay, swimming pools, we had floodlights and used to shine in the midnight. Also, what is their problems? So the court said that there was also testimony from which the trial judge built into the scared were not persons of ordinary sensitivity, taste, and habits, but super sensitive, difficult, and close. Okay, after considering all the circumstances, the court said that Mrs. Claire basically had problems with everyone in the neighborhood. Okay, and she did not get along very well with anyone in the neighborhood. It wasn't for everyone. And it was her super sensitivities which was causing her problem. Because there are other homes in the neighborhood, and no one complained of the nuisance from keywords or their swimming pool, which is very unlikely from the case of Middlebrook Swimming Club. How do the two cases differ? Is that in that case, in the Middlebrook, the resident as a whole, okay, I mean every resident was getting trouble, and they as a bunch, as a group of people, they complained, they defended, and they went to the court as accused. But here, Mrs. Claire was the only person who was having problem with the conduct of the defendant. So in this case, Mrs. Claire's plea was rejected, and no injunction was granted. Yes. Where did it come from? You must have read about violence versus pleasure. What happened? And it disturbed the water quality of the plaintiff's water. Okay, so this was the starting case of, this was the landmark case where the rule of mischief was established. what happened in this case was the defendants employed independent contractors to construct a reservoir on their land. Okay. These contractors, while constructing this reservoir, they found some disused mines, some abandoned mines under the reservoir, and they completely ignored it, and they carried on with their construction. After some time, the mines got it filled the reservoir. As a result, water flooded through the mine shaft into the plaintiff's mines on adjoining property. Okay. The plaintiff secured a verdict at court, and the court held that defendant is liable for mischief because it played or it interfered with the right of enjoyment of the paint. Okay. So it was decided the case was decided by Justice Blackmore, who delivered the judgment at House of Lords and succeeded in his thought the claimant must show that he gave a list of a checklist of product mischief. What are the requirements of he said that the defendant brought something onto his land. Okay. Mischievous, you bring something on your land that escapes and causes problem. Okay. You're having a pet, a dog, and it escapes your property, it goes on to your neighbor's property, and say he destroyed the plants or whatever was there in the courtyard, front yard, and they handed it back. Does it amount to mischief? Yes. Why? It does not fulfill the third criteria of mischief, which says that the thing was something likely to cause mischief it escaped. Because dogs are a very commonly made pets. Okay? And of course, for different nature and all. So dogs cannot be said to be a thing of causing mischief, especially when they are fed. Stray dogs can cause mischief, yes, but if they are someone's pet, now replace dog with snake. You got snake as a pet, no, very adventurous, okay, and that snake escaped your property, went into your neighbor's house, bite him, and dies, or suffers serious injuries. In that case, now yes, it will be a mischief. It was something like you do this. You don't have snakes as a pet. Do you? No, you have snakes at zoo. So, but for that requirement, and it just in law courts, there's this very special criteria of reasonability. Okay, and while judging the tort litigation, judges are always of the opinion. I mean, they always look to the case through the point of view of a reasonable man. Okay. Now, Stairs versus Keepers, Stairs was oversensitive person. Okay, she was not a reasonable person. Now, in the case of snake as a pet, let's say, my right, my rules. Yes, it's your right to you can have snake as a pet, but then you should take due diligence that it should not escape and hurt other person. Okay, so idea of reasonable when it comes to law fraud. I think next case was one versus Stevens. It depends on case to case and just okay. If I were to judge in that case, constantly thinking about the fraud, which is not very have to read it. Now, and you are thinking due diligence because when you have pets at home, you yourself are very careful that your pets are they don't escape or harm others. Okay, you yourself are taking enough care of them, and you yourself are taking due diligence that you should not harm others because you know that you owe a duty of care to your neighbor. Okay, now my neighbor also has a laptop. Okay, if I were to judge this case, I would not give compensation because a lot of things depend on how much injury is caused. Okay, for example, your dog got insane all of a sudden and it went out, it bit the other person, and he was seriously injured. In that case, judges might give compensation. Okay, or the medical expenses. You may be liable to medical expenses. Okay, but that highly depends upon the nature of the activity, your conduct, your social conduct, social behavior, the amount of injury caused to the other person. Okay, your dog just simply came into my premises and it waved its tail and went off. I cannot explain that. How dare you come to my premises? Okay, that is not reasonable. Negligence. Duty of care is the most essential ingredient of this sort. Let's tell you your because we are just finished. I think this is the last slide. What happened in this case? What happens in negligence case? First of all, you owe a duty of care, okay, to the person, to your neighbor, who may not be your immediate neighbor. Okay, it's not the case that your neighbor is the person who shares their wall with you. No, neighbor, you are neighbors. You are sitting with each other. Your neighbors each other. Okay, you are selling a product. You are neighbor with the consumers because you owe a care to the consumers. And if anything harmful happens to them due to your product, it is negligence on you because you paid a duty of care. Okay, and the same thing happened in this Donner versus Stevens case, the famously known as gingerbread case. In the aftermath of this negligence became thought sincere. Okay, and the decision here that the manufacturers owe a duty of care to its consumer. What happened in this case was it came in, the plaintiff ordered a gingerbread and she was having it, and the bottle was opaque, black opaque color, and it was covered with the label. So she could not see the contents of the bottle. Okay, so due diligence on her part cannot be taken by the defendant because in that suit, defendant also claimed that she was having the gingerbread, so she should practice some due diligence there. No, simple name it, we tell the manufacturer that see this and this happened and they compensate it. What happened was payment, she saw that on the label of the bottle, the manufacturer's address and the name and number or email, whatever, the point of contact was written, and she filed a suit against the manufacturer. Now, since this was the initial case of negligence, and people in the law people were so oblivious to this concept that they wondered how can a manufacturer be a neighbor to a consumer whom he does not even know? How can he owe a duty of care to someone he has never met, never seen, never thought of in his life? So in that case, we thought negligence was ahead, and the judge, not acting, the principle of neighbor principle, and it read as you must take reasonable care to avoid acts or omissions, which you can reasonably foresee would be likely to injure a neighbor. Who then in law is my neighbor? The answer seems to be persons who are closely and directly affected by the fact that I ought to have them in mind when I am considering these actions. Okay? So that's precisely the concept of neighbor when it comes to duty of care or when it comes to doctor. That's all. That's from me. And the next slide answers the question asked. So the case of Nike versus McDonald's restaurants. And you know why? Although I'm not very practicing academician of law fraud, however, it is very always interested me. Why? Because the cases in this type of law has been so proximately connected in our daily lives. Okay, the facts that you see in the cases, you can really connect to them. We are the same. Like the same thing happened with me. Exactly the same thing happened with me in Donna versus Stevens. Okay. So I connected it. And it happened while I was writing about this case. So law fraud is a very primitive, basic, fullness form of fraud, which connects to your daily life, which connects to your daily issues. Okay, unlike criminal laws. What for it? You don't have crimes at the end of the day. Okay, you don't have murders, rapes, sexual assaults, or mischiefs. What for it? You don't have that. But these things are your everyday routine. You feel them. Like the misrepresentation by the producers, by the manufacturers. These days we shop everything online. Okay. And what save you when you shop from Instagram? Okay. It is like we talk about you order Gucci, get lucky. So the thought of misrepresentation, negligence, nuisance, it is very relatable in our life. That's the last slide. And in the case of Nike versus McDonald's restaurant, what happened is lady died. She died in hospital. So back then she was an elderly person. She ordered a company. And she got the copy of the car and put the copy on the desk. Okay. The moment her son or grandson ignited the car shook and the printed copy was spread all over her, especially giving her pelvic area serious burns. Okay. she says in her lawsuit was that it was third-degree murder. That's what her attorney said. All right, and at that time she got a huge compensation from it. Why this judgment is landmark in itself? Because it was $640,000. It's a fortune amount. Okay. So why this is important? Because after this case, the big corporate houses, big business houses, who manufacture coffee or any part beverages, you started writing this warning on their cups that the content may be hot, be careful, because no one would want to pay that amount of money. Okay, so that's all, folks. I hope I've told you. And any questions? Regardless of the fact that maybe you are involved in that robbery, in that night play thing, okay, provided you are not involved in that, you will not be able to. And a lot of other things come into picture. Like you care for the neighborhood. Why? If the things were in your control, like the judge would see, I would see whether what are you in a position to stop the act at that time or not. Because if you stop it, you are somewhere liable for your breach of trust for your neighborhood, for your duty of care for your neighborhood. Anything else? Questions, comments, suggestions, feedback? We have to study who you can put it on the like chill. So you want to school? No, I must not. No. Because first of all, you're not in it, and till the time you are under the surveillance or the school owes you a duty of care. Okay, so for your safety, for your benefit, if the school is using such sort of cameras, they are allowed conditions. Other people like. Then school boards I used to give first to students and then to the leaders. Okay, so for the benefit of students is primary for the school, then the benefit of the students. I think school would be. Any other cases, please? Questions
Any other question?
or suggestions? Feedback? You are in the interest and for the other person giving you. You are. That's what is social. Plus, we have to start from this particular result. So what happens is everything's according to law thought is not that practice area of something. In other legal systems, especially like Australia and UK, their legal have standards. In that, in those legal systems also, for especially these road accidents or these sort of things, people go for remedy under motor vehicle traffic because that legislation is more efficient in dealing with the road accidents than the government. This sort of negligent while driving is very well covered under the motor vehicle act. Damage is covered under the motor. So the remedies that you can create there, the damage is going to be more beneficial.
Thank you so much, friends, for such an insightful session. As we express our gratitude, we must never forget that the highest appreciation is not to utter words, but to live by them. So, to show gratitude in our actions, may I request Professor Praval Pratap Sir, HOD of Law Department, to present a memento as a token of gratitude to our guest speaker. Thank you, sir. Now, moving forward, I would like to invite Professor Ms. Kathy Naik ma'am to propose a vote of thanks.
Thank you so much, ma'am, for today's session. And I think the students must have benefited from today's session, and they must have gained a lot from today's session. And here I am on behalf of Department of Law, Prestige Institute of Management, Gwalior, and it's my honor to propose a formal vote of thanks for you. And thank you so much, since you are our showstopper for 5 days orientation workshop 2021. And like it was our intention to make this orientation workshop as a bridging course for the new students, because all of them, they are all freshers and they do not have much knowledge of law, right? So we wanted to make this orientation workshop as a bridging course so that when they enter the classroom, they have at least the basic knowledge of the subjects that they are going to study. Okay, so I hope that our motive of making this workshop a bridging course is fulfilled. You, along with all these speakers we have had in these 5 days, they were wonderful, and it was wonderful having you here today. And thank you so much for sparing your wonderful time and being here all the way from Delhi, okay, for today's session. I'm sure that students have gained knowledge in all of these 5 days. So thank you so much, ma'am, and thank you to all the students for being here. Okay.
Thank you, ma'am. All of us do not have equal talent, yet all of us have an equal opportunity to develop our talent. With these lines, we are ending our session. Thank you, students, to calmly attending this session. Please wait till your attendance is being marked. Thank you.
Since this is our last day, so I would request you, all of you, to come forward and have a group photograph, please.
Please come forward. One more girl row, please. One more row, can. Next.
वहाँ पे जगह कहाँ अभी ऑलरेडी वो खड़े
मैं यूट्यूब लाइव बंद कर दूं? please be seated for 5 more minutes. Attendance will taken by Rishabh and Betsy.
Kapil भैया
Attention students. Now this is the call for BA and MB honors. Anand Goyal, Aditya Yadav, Akansha Kumari Patel, who was this diary? Certain. Akansha Kumari Patel, Akansha Yadav, Akash Bazoria, Akshat Singh Yadav, Alok Singh Rajawat, Anjali Kumari Patel, Ananya Chaube, Apurva Tiwari, Aarti Sharma, Deepak Sharma, Nishit Pofli,